Class member Kathleen Kennedy was elected to the Circuit Court of Cook County, Illinois in 1996 and served as a judge for 20 years. Previously, she was a law clerk for both a state appellate judge and a federal trial judge, and she worked as a government lawyer representing abused and neglected children. Kennedy has a law degree from Northwestern University. So let's hear it for Kathleen Kennedy.
Good morning, and first I want to say happy birthday to our Constitution. It's 238 years old today, born in 1787, and hopefully we will keep it going strong. So I want to start with a little bit of follow-up from last week. You'll get a document entitled Third Branch Sources, Resources, and in that document you'll get additional follow-up on the public financing of elections, which one of our members indicated responds to some of the concerns about public financing of elections mentioned last week, and some of your other questions from last week. So I tried to put some of that in the Third Branch Sources and Resources. And I even included, based on a question from last week, the latest map of the Cook County judicial subcircuits. That'll definitely be worth the price of admission. So let's see. So look for an email that will have that. It's probably a week, hopefully sooner. Okay, so to follow up on last week's 2024 Michigan Supreme Court campaign financing issue, we gave you some ads, but we didn't give the numbers that went with those ads. So the estimated total TV spending for the candidates was $1,095,700, over almost $2 million. No, almost $1,100,000, sorry. And they also had an outside group supporting them called Justice for All Michigan, and they donated $126,000. So these are big numbers. And what I did with this information is something I think voters could do, because it's all available online. So first thing I wanted to do was find out who was Justice for All Michigan. So, okay. So I looked it up online, and their website said Justice for All Michigan is an organization and resource for the citizens of the state of Michigan seeking more information about the nonpartisan judicial part of their ballot. And it supports individuals running for judicial positions who have demonstrated that they are in pursuit of a fair and equitable justice system. And then because I'd run across it before in my research, I took a look at Influence Watch to see what they would say about this Justice for All Michigan. And Influence Watch said it was a left of center political organization that was launched to support the election of Democratic Supreme Court candidates. So then I started to wonder about Influence Watch. And you know, I wondered if is it called a rabbit hole when you're just trying to get reliable information? Shouldn't it have a better name? I mean, it didn't feel like a rabbit hole. It felt like I was moving in the right direction. Anyway, I found out that there's this, and maybe everyone knows this already, but I sure didn't. There's a site called Media Bias /Fact Check. And that is a group that rates sources on their reliability and their political bias. So they do they rate media for political bias and factual reporting. And they gave Influence Watch 6.2 out of 7 on having a right bias. And then but they also gave Influence Watch a good rating for their fact checking. So looking more at media bias fact check, it seems there's a whole industry out there on fact checking and finding out what's true. And I think that's good. The third thing I did was just to check out the Michigan Secretary of State campaign finance searchable database, which you'll get the site for that. So you can do a contribution search analysis, and you can look at expenditures. And so just to test it out, I went on and asked for, you have to use the committee name, or one way to do it is the committee name, the committee Kimberly Thomas for Michigan Supreme Court. And I just took a brief look at the results. And it's very interesting, time consuming, but if it's something someone could do if they really wanted to find out more about candidates. Then I wanted to go back for a minute about the religious affiliation of U.S. Supreme Court justices. And I wanted to clarify that I didn't mean to suggest that religious beliefs dictate judicial decision-making. I pointed out the religious makeup of the U.S. Supreme Court merely as a point of interest with regard to religious diversity, which may or may not be important to voters or the appointers of judges. And we all know that judges bring all they have, all their experience, their culture, their background to the bench, and they just have to make sure they're deciding impartially. So I tried to find out the Michigan Supreme Court justices' religious affiliations, and one search said they're private unless the judge wants to disclose them. And it also indicated another search gave a whole bunch of religions for people who never sat on the Michigan Supreme Court. So anyway, and then I came across Governor Whitmer's statement after she appointed the most recent Michigan Supreme Court justice, that we will keep working together to build a justice system that looks like Michigan. So, I mean, diversity may be an issue and religious diversity may or may not be an issue, but I just thought I'd let you know why I got there. Okay, so on to judicial conduct. I'm giving you here the 10 commandments for the new judge. On my first day as a judge, I knew something about the judicial campaign speech rules, but I'd never read the code of conduct. They call them the canons. I went to judge school for about a week, taught by experienced judges, and they did not hand out these commandments, but they gave us copies of a book in which I found them. The book was called Handbook for Judges, an anthology of inspirational and educational readings, put out by the American Judiciary Society, which still exists, an organization that I believe is truly nonpartisan and really works for independent justice. The two pieces of advice from judge school that stood out and stuck with me: one, don't try to be funny on the bench because you may not be that funny, but everyone in the courtroom has to laugh at your jokes. And two, most important, don't catch robitis, which, for those of you who don't know, is a horrible disease in which wearing the black robe goes to your head and you think too much of yourself. After judge school, I spent 2 weeks observing judges in different courtrooms, and then waiting for my first assignment, which was called Expedited Child Support Court, which was in Cook County. There were 4 high-volume courtrooms dealing with child support and parenting time, which was then called visitation, for children whose parents had never been married to each other. So anyway, I like these 10 commandments. They're clear and a judge might do well to follow them, but there are more specific rules. Before I get to them, I just want you to take a look at these quotes by Justice Scalia, who died in 2016, and Justice Kennedy, now 89, who served until 2018. So the reason I have them here is because I think it's really important to indicate that a judge won't always like the decision he or she makes. And I have a couple examples of my own. I had one case where my ruling would make the difference between a young man with a young family keeping or losing his dream job based on a stupid act of what I'll call small-scale shoplifting. I really didn't want him to lose his job. It was what he did seemed so little compared to all that he would lose. And I went over and over the evidence. Really, I took way too long on this case. 4 months, not 4 months. I looked for several months, just seeing if there were any facts that would support kind of the ruling that I kind of wanted. And I looked and I couldn't find it. And I had to go with the ruling I didn't want. And he lost his job. So that was on the facts. In another case, it was a case brought by a very sympathetic group working for a good cause. But if I followed the one important and direct precedent, then they had to lose. I didn't want them to lose. But I read their briefs over and over, and I read case after case to see if there was any way around this precedent, and there wasn't. So the group had to lose on the law. So judges, you make the decision, you apply the law to the facts, and you might not like the decision you reach, but that's where you have to go. So we have a code of conduct for the U.S. judges. The code is published and updated by the Judicial Conference of the U.S., which is the national policymaking office of the federal court system. So let's take a look at the canons for federal judges. And first, I think maybe you're aware because there was some publicity about it, the U.S. Supreme Court does not need to follow or have to follow this canon. And we'll get a little more into what they have done in a minute. So each federal canon has a commentary, which has a lot of detail and specifics, and it's a lot of information. It's complicated, and you can read it yourself. But I just want to note a couple things. One will give you a flavor of the enforcement or lack of it of the code of conduct. And it's okay, in my opinion, it's okay not to be heavy on enforcement because you really can't, there are two important underlying concerns. You can't like mess with the substance of a judge's decision-making, and you have to recognize that judges are human and they make a lot of mistakes. So the commentary to the Code of Conduct for the U.S. judges says that not every violation should lead to disciplinary action. Disciplinary action and degree of discipline should depend on factors like the seriousness of the improper activity, the intent of the judge, whether there's a pattern of improper activity, and the effect of the improper activity on others in the system. So it's not supposed to be for civil or criminal liability. It simply provides the standards for the discipline of judges in the federal system. A couple things to point out is that a judge should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. And a judge can't lend the prestige of judicial office to convey that someone is in a position to influence the judge. And the judge must avoid all impropriety and appearance of impropriety. And here's some legal mumbo jumbo of what that means. Impropriety occurs when reasonable minds with knowledge of all the relevant circumstances disclosed by a reasonable inquiry would conclude that the judge's honesty, integrity, impartiality, temperament, or fitness to serve as a judge is impaired. So, like I said, it's a lot. So impropriety and the appearance of impropriety apply to both professional and personal conduct. And judges can't make comments, public comments, on the merits of a matter pending in the court. There's a section on disqualification and when that happens. And I just want to point out that you hear the terms just disqualification and recusal, and they have slightly different meanings, but they're really pretty much always used interchangeably. Disqualification is mandatory and recusal is voluntary. And I have a personal example to illustrate the difference. So one morning I was sitting in my chambers and my clerk said, alderperson so-and-so is here to see you. Like, I don't know this person. Why isn't, should I say alderman? Why would an alderman come to see me in my chambers? I'm wondering. So I wasn't going to be rude. The alderperson came in and started to talk about a case. And I said, oh, you're going to have to leave now. And so I let the clerk know that I was going to recuse myself. So it was mandatory. I mean, it was voluntary. I was going to recuse myself from the case that this person was telling me about. So if she had told me, or if the alderperson had told me a lot of facts of the case, then I think it would be mandatory that I disqualify myself. But I hadn't really heard anything about the case. So I just recused myself just to be on the right path. So also there's a complicated thing in the canons, if you look at them, that talks about the third degree of relationship. So there's certain rules that apply when you know someone or when someone in your family, if there's a relationship, and it goes pretty far to grandparents, great-grandparents, aunts, uncles, and so on. So this is when a party or a lawyer in the case, there'd be a conflict of interest because of this relationship between the judge and their grandparents, great-grandparents, et cetera. So as far as the U.S. Supreme Court goes, the justices issued their own code in November of 2023. And they issued a statement with their code, which essentially says, we've been following the judicial ethics rules all along, and somehow there's been a misunderstanding that because we had no code, we had no restrictions. So we're issuing this to clear that up. And you may remember some of the context around that code, which were some negative, well, there were some allegations of undisclosed gifts and conflicts of interest potential by Justices Alito and Thomas. And before that, more negative publicity, Justice Ruth Bader Ginsburg in July 2016 made disparaging remarks about then candidate Trump. And so these are things that was something judges can't do. There's rules about gifts and so on. So they came up with the code, and it's been criticized for lacking penalties and an enforcement mechanism. It's a lot like the code that you're looking at on the screen, except there's a lot of different rules about recusal, meaning taking yourself off the case, because there's only 9 of them and they can't really substitute anyone, and not having a majority vote can have an effect on the decision. This year, excuse me, Supreme Court Justice Barrett recused herself from the case involving a public religious charter school, excuse me, oh, sorry, in Oklahoma. This was voluntary. It was a recusal. It was a recusal, which was voluntary. And she didn't state a reason. She doesn't have to, she didn't have to state a reason. And the media suggested that her recusal might have been based on her very close relationship with one of the lawyers who had been an advisor to this religious charter school. They were very close. They clerked together on the U.S. Supreme Court. They were family friends, godmother to one of the kids, et cetera. So that was kind of the suggestion about why she recused herself. But it's fine that she didn't say so. She doesn't have to. You never have to say why you're recusing. I didn't have to say because the alderperson came in my office. So because of that, and this is one of the things the Supreme Court Code talks about, they tied 4-4 on that case. So that meant the Oklahoma State Court ruling that prevented the religious charter school had to stand. So in other words, in their code, they note that things are different for them because if it's 4-4, the plaintiff essentially is losing. And if it's 4-4 in the other, it could also mean that there's no settled law when there needs to be settled law. So that's about the U.S. Supreme Court. Now, the Michigan Code of Judicial Conduct is very similar to the federal canons. They both reflect the same standards of integrity, independence, impartiality, and diligence. And again, that interesting, rather ambiguous prohibition against about avoiding impropriety and the appearance of impropriety. And it applies to all activities in Michigan. And the federal code says refers to professional and personal conduct. Also, the rules require judges to make sure, I think this is in Michigan, and maybe most states, to make sure also that there's non-discriminatory conduct, and some of the appearance of impropriety has to kind of extend to the court staff and the people the judge can control in a way who they're working with. So, for example, in my experience, I found out that my clerk, so there's a courtroom and there's a clerk sitting nearby who calls the cases. And when I was in my chambers, I found out that my clerk was selling pies to people coming into the courtroom, like the lawyers and parties. And I was like, wow, she's selling pies. Are they going to think that if you buy a pie, the judge is going to rule in your favor? I really couldn't believe. To me, it showed an absolute lack of understanding of the judicial system, and she was the clerk for a long time. So I talked to her supervisor and said, we'll give her some training. Also, I found out, it was kind of indirect, that in the other courtroom I was in, there was a clerk and there was a deputy sheriff sitting on the other side. And while the case was going on, it's kind of boring, so he's doing something. He's really reading a girly, I call it a girly magazine. So like he's sitting there and someone's testifying and there's this magazine like displayed. So I had to talk to his supervisor also. Anyway, so things can come up. So there are specific rules on the receipt of gifts and mandatory financial disclosure statements. In 2022, a federal law, the Courthouse Ethics and Transparency Act, requires online publication of financial disclosure reports. So there's a database. You can go right on there and read all about the federal judges. Michigan also has the same requirements, but in Michigan, it's not a database right now like that. They're not in a searchable online database. I came across a reference to the Free Law Project, which says that it has a structured database with information about more than 16,000 federal and state judges, their investment records, gifts, and everything that they have to disclose. So you can find out a lot. Okay. Now, the rules on recusal and disqualification, which I referred to, talk about, these are just a few of the many issues that you come across. So the Code of Conduct in Michigan says a judge should raise the issue of disqualification whenever the judge has cause to believe that grounds for disqualification may exist under the rules. And also, the parties can waive disqualification. They can agree to let a judge stay on, even though there's a possible basis for disqualification. So in Michigan, and this is all online, you can read it, we have a very convenient judicial disqualification checklist. So the judge can simply go point by point and decide whether he or she has a reason where they have to disqualify themselves. It's important to note that in Michigan, the rules are in line with and specifically mention disqualification for bias under what's called the Caperton decision. So I don't know if you remember from last week, there was the West Virginia case where the CEO essentially fought the judge and then the judge didn't recuse himself. Well, it went up to the US Supreme Court and the US Supreme Court ruled that judges must recuse themselves from cases of major political donors and supporters. Of course, this only works if you have strict disclosure rules for direct and indirect campaign spending. One scholar actually believes that if this works, if the judges have to recuse themselves based on large campaign donations, it will make judicial elections more transparent than political appointments because it's out there and you see what's going on. Okay, so the next question is though, this is more of the checklist, and there's also a handy flow chart, which Amy told me that it's not really a flow chart because it just goes around in a circle. But anyway, so the judge really has a lot of tools. I mean, it's important. So I think the state, Michigan's making a big effort to make it easy to decide that you should disqualify yourself. But how could that ever be easy? Social science studies show us that we are prone to see ourselves in the best light and think we are more fair and ethical than others. And we are inherently disadvantaged at recognizing bias in ourselves. So this bias blind spot, or one of my law school professors, Steve Lobet, he's an expert on judicial ethics, calls it introspection deficit disorder. So we have to decide ourselves whether we are biased. And it would be really hard for any of us really to say, well, I can't do this because I'm biased against you. I mean, that's hard. But even harder maybe is to say that your next door neighbor judge is biased because you work with that judge all the time. And I'm not biased, but you're biased. So it's a hard thing. I would say it takes moral courage to disqualify yourself. And so Michigan has some safeguards against this judge deciding for him or herself. So if there's a motion to disqualify and the judge who's being asked to disqualify him or herself denies it, then the motion goes to another judge to decide. And in the Michigan Supreme Court, the justice must decide and publish his or her reasons. And if the justice denies disqualification, then the party asking for disqualification can ask for it to be decided by the entire Michigan Supreme Court. And again, there have to be reasons in a written order. Okay. In the federal system, the ultimate discipline is impeachment. And it doesn't happen very often. The last federal judge to be impeached was removed in 2010 for what was, I didn't read the whole thing, but corrupt conduct and making false statements about his past. The first judge convicted by the Senate was in 1809, and he was removed on the charges of mental instability and intoxication on the bench. So only one Supreme Court justice faced an impeachment trial, and that was in 1805, Justice Chase. It was charged by the House that he made partisan decisions as a lower court judge before he joined the Supreme Court. And a Senate, packed with Jefferson's allies, acquitted him on all counts in a trial presided over by Vice President Aaron Burr. You can read all about impeachments at the Federal Judicial Center. Kind of an interesting topic, in my opinion. And you'll have the site for that, or the website for that in the resources and sources. So you may be aware that there have been recent impeachment efforts. In 2025, House Republicans introduced impeachment resolutions against federal district judges who issued rulings that temporarily blocked policies implemented by the Trump administration. Specifically, a judge from the Southern District of New York who blocked the dismantling of the Department of Government Efficiency, a judge from the DC District Court for ruling on deportations, two other judges from the US DC District Court for blocking administration policies. These resolutions are pending in the House Judiciary Committee. The New York City Bar Association issued a statement condemning these impeachment threats, arguing that they are based solely on a disagreement with specific court decisions and undermine judicial independence. And even Chief Justice Roberts issued a statement, a public statement, that for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. So again, impeachment is the ultimate discipline, but it's not the only avenue for problematic judicial conduct. And most judges who make mistakes in their conduct are able to keep their jobs. Maybe they have training or they get a public censure. There's all kinds of, it's very confidential up to a certain point. So you can file a complaint against a federal judge. Anyone can file it. Then there's a review, investigation, and then another review. And then there's a decision made whether it's going to be public or stay confidential. And many complaints are dismissed or resolved confidentially. And the public never knows about the details about these claims of misconduct by federal judges. And when it does become public, it's on a website. So you can search for these on the website and you can read about the cases. You can read about what the claims were, what happened, what they decided. The federal judiciary recently published updated statistics and said that there were 1,510 judicial conduct and disability complaints against federal judges in 2024, which was up 11% from the year before. And most of them are dismissed and we never hear anything about them. Okay, so judicial discipline in Michigan is similar. Again, there's the confidentiality that happens until a certain point when it can become public. You can look at the documents online. You can read about judges. And when I was a divorce judge, I had a emotional and very sad case, and my rulings were making the husband very angry. So one day in court, he asked me for a change of judge, which they're allowed to ask if there's bias. And because he filed a complaint against me with the Illinois Judicial Inquiry Board. Of course, I didn't know that he'd filed a complaint against me because it's all confidential and most complaints, like I said, are dismissed, and especially if they're on the merits of what the judge is ruling. So, and then also, I didn't know about it. Now I know about it. So he said, well, now you know about it for sure. You have to, I need a new judge. I get a new judge. And I said, well, no, you can't recuse yourself or disqualify yourself based on someone asking for a new judge, because if I did that, they'd always get a new judge. So anyway, this is our Michigan system, the Judicial Tenure Commission. And it's very clear, nice PowerPoint that I borrowed from the head of the Judicial Tenure Commission. And so, you know, it's the same thing. There's an investigation. Some investigations lead to private resolutions, like sometimes they give a warning, they give some training. It's kind of interesting that there were concerns raised by the Association of Black Judges of Michigan. They thought there was some disparity in the process for Black judges, and they had a racial equity analysis by the National Center for State Courts. And the interim report did find statistically significant racial disparities in 3 parts of the judicial discipline process. And there's an ongoing review to determine the causes of disparity and whether there was any bias in them. The review was supposed to be completed in July of 2025, and I'm sure it'll be online when it is, but I didn't see it yet. So there were a lot of, well, there were 622 requests for investigation concerning 373 judges in 2024. So again, this is just kind of the, what can happen to the judge. If it's public, then there are 3 public complaints against judges going on right now. So you can read all about them. They can be removed from office. I guess that's the ultimate. Sometimes they retire in the midst of the investigation or some other time, so they don't have to get there. This is the 2020 types of grievances. You can see that 49% are about the illegal ruling, which really can never be a cause of discipline. So I'll just give you a couple of examples that I read, and you can read online about the what happened to certain Michigan judges. One criminal court judge received, after the complaint and investigation, received an explanatory letter to make the judge know that the perception existed that the judge was punishing defendants for going to trial, and to stress the importance of not creating. So it's kind of corrective. You know, you're doing this. It violates the code, but we just need you to stop doing this. So it's kind of educational. There was so that was called a explanatory letter. One judge got what's called a caution. He referred to the defendant as a clown during the arraignment on a misdemeanor case. And they said they would have maybe done harsher discipline, but the judge took full responsibility, said it wasn't right conduct for a judicial officer, and said he allowed his frustration with the defendant to get the better of him. So, I mean, we're human. And then there was another judge who was cautioned because she exchanged ex parte emails to members of the prosecutor's office, sharing her personal feelings about cases and critiquing investigations while trials were going on. So that was gave the risk of an appearance of partiality toward the prosecutor's office. And I did find one off the bench conduct where a judge was, I don't know what the discipline was, but he committed the misdemeanor of carrying a loaded unregistered handgun in his bag at the airport. So okay. So judicial conduct is really interesting. And if you really want to know about these judges, you can read about them. I found it kind of fascinating, but now we'll move on to judicial independence. So do we need a declaration of judicial independence? Let's see. I'm going to introduce you to an Illinois judge who's going to talk about judicial independence, because in 2022, they held a judicial independence press conference and issued a declaration of judicial independence.
Today, the Illinois Judges Association, along with over 18 different Illinois-based bar associations and legal groups, and that number keeps growing, is issuing the Judicial Independence Declaration in advance of the upcoming general election. This project grew out of a concern in the legal community that judges were being targeted by ideological groups on both sides of the aisle. Our concern is if the judicial branch of government were to start deciding cases based upon who yells the loudest, we're all in trouble. Our entire democratic system depends on the judiciary remaining independent from political winds. Judges are a unique branch of government in that it really doesn't matter what political party you belong to. What matters is whether you apply the law to the facts in a fair and just manner. That's it. The Judicial Independence Declaration lays out the principles and the reasoning for the necessity of ensuring an independent judiciary. It stands for the proposition that everyone gets a fair shot, that the judge making the decision should not and is not influenced by partisan politics or ideology. Judges should be evaluated based upon how they do their job, how they render decisions. Are those decisions based upon the law and the facts? Is that judge fair and impartial?
So our goal, of course, is judicial independence, and it, oops, sorry, back to the, oops, yeah. It doesn't mean that you decide the way you want it, and independence means you decide according to the law and the facts. And the law and the facts do not include deciding according to campaign contributions, which is from Justice, now retired Justice Stephen Breyer. The University of Chicago puts it this way: judicial independence refers to the idea that judges should be insulated from undue or improper influence by other political institutions, interests, and/or the general public. Independence is closely related to the idea of the rule of law. Legal strictures should be applied in a consistent, impartial, and unbiased manner, irrespective of the identity of litigants or judges. So the rule of law is everyone, I mean, conservative and liberal scholars say the rule of law is exceedingly important. And judicial independence is interrelated with the rule of law. What we need to do in our constitutional system can only be done if there's an independent judiciary. Judges have to be free to make decisions without intimidation, without interference from the executive branch or the legislative. Scholars say that the American public has always wanted an independent judiciary. I have to say that personally, at this point, I sometimes question whether our extreme polarization leads us to not really want an independent judiciary. It seems that maybe we or some of us want judges who are on our side. It's a scary thing to accept rulings that are based on thoughtful application of the law to the facts when the rulings are contrary to your values or beliefs. So it's a hard thing to have an independent judiciary, but we have to have it, and we have to accept rulings that we don't like, as long as we find that it's been done impartially and fairly. It's concerning that perhaps certain branches of government don't value judicial independence. Okay, moving to judicial security. There have been more than 400 threat investigations as of June. And I just put a quote that, because I didn't want to read it out loud, of a voicemail that a U.S. District Court judge, the chief judge in Rhode Island, received after temporarily pausing a Trump administration attempt to freeze federal grants. So there's been murder in the court system of federal judges. Honorable Joan Lefkoe on February 28th, 2005. Her husband was at her home recovering from surgery, and her mother was visiting from out of state. And a disgruntled litigant murdered both of them and then hid in the basement waiting for her. But her daughter came in from school, didn't know he was in the basement, went and grabbed something and came out. I think it scared him away, and he left. He admitted he maybe 2 days later died by suicide. 15 years later, in July of 2020, Honorable Esther Salas in New Jersey, her 20-year-old son answered the door, and a lawyer posing as a delivery driver killed him. So in Judge Lefkoe's case, the murderer was a litigant. In Judge Salas's case, the murderer was a lawyer. So these were people involved in the system. I mean, but who's next? I mean, where will it come from? In Chief Justice Roberts' 2024 year-end report, he said there were more than 1,000 serious threats against federal judges that were investigated by the U.S. Marshal Service. And in the last 5 years, more than 50 individuals criminally charged with doxing and grassroots campaigns to bombard offices with threatening messages. And Chief Justice Roberts said there is a right to criticize the work of the judiciary, but the public should be mindful that intemperance in their statements when it comes to judges may prompt dangerous reactions by others. The U.S. Marshal Service is the branch of the government that protects federal judges, and they actually launched, after Judge Salas's son was murdered, they launched a program to help judges and their relatives, like it's called the Vulnerability Management Program, and they scrub the internet, scrub their websites somehow. They scrub personal info from websites, but it seems to me that if you want to find someone, you probably can. So there's words that affect the security of the judges, like, this is a miscarriage of justice. It's sad to watch. The judge's bias may have jeopardized the entire trial. They target judges and name family members, and it's hard for judges to respond to this rhetoric because if they say anything, it could look like they're taking sides. Also, they depend on Congress for their funding, and they're limited by ethical rules about what they can say. A professor at the University of Pittsburgh who studies disinformation said that ideally government officials and owners of media platforms have a duty to democracy. He said that attacks on judges and other democratic institutions are straight out of the authoritarian playbook. So sometimes I wonder if it's possible to have a rhetoric that can counter this extreme rhetoric that we're hearing, and keep judges safe. Judges have talked about this in like conferences, and they describe it as inviting people to do them harm. Judge McConnell, who received this voicemail, said that his court received over 400 vile, threatening, horrible voicemails, and 6 credible death threats were made against him. He said he's never spoken about what's happened to him personally because he's not looking for pity or sympathy. He just wants to be able to do his job. He just wants to be able to uphold the Constitution. So several judges around the country have received that pizza doxing, where you get these deliveries of pizza, and they're done in the name of Judge Salas's sons. So it's just unbelievable. Okay. To get off this subject, I just want to add that yesterday or the day before, I read that after the Kirk killing, the Trump administration asked Congress to approve $58 million in emergency funding for the U.S. Marshal Service to bolster security for the Supreme Court justices and lawmakers. And the FBI recently reported 17 open investigations into threats against federal judges. So, politicization of the judiciary. I think it's always been there. I mean, judges have often been perceived as political or politically motivated. And Can you ever vote a judge out based on a decision that they made? Would that be political? What circumstances could you do that in? Now, I was wondering, if US Supreme Court judges were elected, would you vote them out because of the Dobbs case that undid the right to abortion? Or would you vote them out because of the Citizens United case, which allowed massive funding by unnamed corporations? Would you try to vote them out based on a decision you disagreed with? And is that politicizing them? One scholar suggests that the way around publicly unpopular judicial rulings in the states is constitutional amendment, which is much easier in the states than in the federal constitution. So the question is, how do we protect the court system and insulate it from delegitimization that occurs when losing parties lash out at the judicial decision maker? It's disturbing to watch the focus change from law and precedent and onto the judges themselves. Although judges should not be treated as purely objective and rational beings who are above politics. It's a difficult question. I mean, judges are working in a political sphere, but they shouldn't be politicized. And I honestly, I don't know. Maybe in the question and answer, you can tell me what you think we could do about it. Okay. Moving on to the shadow docket, which is very prominent in the news, I guess I would say. To me, there are two things to consider. The approach, the way these rulings are made, and the numbers, which is on the next docket, next slide rather. This is from a recent, the New York Times commission or whatever they do, got a group to do this analysis. So to me, there's two things to consider: the approach, the short, unexplained rulings, and the numbers favoring the administration. And combined, it suggests that maybe the Supreme Court really has to consider a different approach for the court to have any legitimacy. So going back to the, well, I won't go back. So the shadow docket is a term that was coined by a University of Chicago law professor in 2015. So it's really an emergency ruling, and it was used before. It was often used on emergency cases of death row inmates who wanted to block execution at the 11th hour. A recent article, which I'll cite in the talks, did an analysis and says a lot more about how often it was used, and maybe this is exaggerating to say that it was mainly used for death row inmates, but that's one of the points that have been made. Justice Alito said in a 2021 speech, quote, "The catchy and sinister term shadow docket has been used to portray the court as having been captured by a dangerous cabal." He said this portrait, quote, "feeds unprecedented efforts to intimidate the court or damage it as an independent institution." He said the court's processes are fully transparent. And he said, quote, "When we issue an opinion, we are aware that every word that we write can have consequences, sometimes enormous consequences. So we have to be careful about every single thing that we say." But you have to ask yourself, what about the confusion caused by what you don't say? So there was a NBC News report from September 4th where 12 judges spoke. They weren't identified by name. And they said that they're doing their jobs, yet it looks like they're not, because they do their job, they apply the law to the facts, and they issue their ruling, and then it goes up to the Supreme Court in a quick track, and without briefing, without oral argument, and then they get reversed, essentially. And they don't really know why, and it looks to the public like they're not doing their job. They worked at it, but they were wrong, and it was wrong. So Justice Kavanaugh relatively recently spoke about the shadow docket, and he suggested that it should be called the interim docket because it's shadow docket, again, suggests secrecy. He said that the court issues terse orders on the emergency docket to avoid the danger of locking them in when the case is fully briefed, which it could contain snap judgments, so they can't put that in there. He also said it's the product of compromise, and brief unsigned orders can be the product of a delicate compromise between the justices to reach a consensus. But I don't know how much of a consensus they've reached on some of these cases. He says they've been doing more writing, and actually that article in the SCOTUS blog says over history there has been more writing on the emergency docket. I think there is this confusion for the lower judges about what the Supreme Court is saying. And I think I mentioned last week the case of Judge Young, a Massachusetts judge. I just wanted to talk about it because it strikes me, I mentioned robitis. It strikes me as the ultimate robitis. So Judge Young found that the Trump administration's termination of the National Institute of Health research grants related to DEI was void and illegal. And after he did that and he was reversed, Justice Gorsuch, joined by Justice Kavanaugh, had harsh words for him. Now, Judge Young is 84 years old. He was a Reagan appointee. He's had an amazing career, and he works really hard and does a really good job. And according to this news report, he seemed to be reeling from a blow to his reputation administered by the Supreme Court. So Justice Gorsuch said, quote, "Lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them." According to Justice Gorsuch, joined by Justice Kavanaugh, Judge Young had ignored the reasoning in an unsigned 4-paragraph interim order that was entered in a different case in April. Justice Gorsuch acknowledged that those orders are not final determinations, but said that, quote, "even probabilistic holdings must command respect." Quote, "Whatever their own views, judges are duty-bound to respect the hierarchy of the federal court system created by the Constitution and Congress." So it's very unusual to criticize a judge like that, for a reviewing court to criticize a judge like that. And one of Judge Young's colleagues responded. She said, "The Supreme Court's recent emergency docket rulings regarding grant terminations have not been models of clarity and have left many issues unresolved. It is unhelpful and unnecessary to criticize district courts for defying the Supreme Court when they are working to find the right answer in a rapidly evolving doctrinal landscape, where they must grapple with both existing precedent and interim guidance from the Supreme Court that appears to set that precedent aside without any explanation." So there's different spins on this shadow docket issue. One spin is that the majority of issues rulings issued by the trial court judges are temporary restraining orders. They're meant to keep the status quo in place while the court hears fuller arguments. So whether to issue a more permanent block against a policy or action. So these temporary rulings that are being reviewed and essentially rejected often by the U.S. Supreme Court are, according to my former law professor, Steve Lubet, quote, "actually a conservative thing for a judge to do." So when they stop what's going on and they're maintaining the status quo, what existed before this new action took place, to kind of wait and find out through briefing and hearing, if necessary, what should be done to have a chance to apply the law to the facts. My own spin is that during my last 4 years on the bench, I occasionally faced a request for a temporary restraining order or a preliminary injunction. So it's a temporary ruling essentially on an emergency basis when you haven't had a trial and you have to make a quick decision without a whole lot of information about the facts. And you have some information about the law, but there hasn't been time for it to be fully fleshed out. So, but you have to make a decision. So the standard that applies to that decision that's most important to me is the standard of irreparable harm. So if the emergency relief is not granted, who will be harmed? Is it irreparable harm? So if you have, I don't want to use these examples, but the idea is that you have to look at what harm will occur if you deny the motion, if you don't allow the emergency relief. But I was just a lowly state court judge, so my spin probably doesn't matter. Now looking at the stats, you know, consistently favoring an administration, my question is that impropriety or the appearance of impropriety? At first, you might think, yes. I mean, how could it possibly be? But that goes to the substance of the decisions. And you can't, impropriety doesn't depend on the substance of the decision. It's just not how it works. So the shadow docket is a question, and it's just, no matter how you look at it, it just, well, not no matter how you look at it, it looks to some of us as if the US Supreme Court is just rubber stamping the executive branch. And, you know, that's not how it's supposed to work. Okay, that's a lot. And so we'll switch to, why can't it just be AI? I mean, we're just calling balls and strikes, right? So, I mean, let AI decide. So there are some, you know, places where they are using AI in the judicial systems. And there's some articles about it. I think the most interesting thing that I read was that it might not be a bad idea to try AI in some small types of cases and just see how it works. I mean, I thought that was maybe valuable. I guess it depends on what you want in your decision making. I mean, clearly at this point, there's not going to be any empathy. There's not going to be like a human understanding. I guess there's concerns about discretion and ownership of the model that you're using, and transparency. I guess if you really love efficiency and bias mitigation, access to justice, those can be improved with AI, I suppose. Chief Justice Roberts weighed in on this and said that he thinks judges are going to be around for a while. He said, let's see. Anyway, yes. He predicted in 2023 that human judges will be around for a while. I don't know. There's some articles. I think, in my opinion, on my experience, one of the most important things is the feeling that you've been heard. That I think there's studies that show that if a litigant feels they've been heard, they're more likely to comply with the ruling, even if it was against them. So I don't know, you read about AI therapists, and I'm sure they get the patients feel like they've been heard. So maybe it can work. Maybe I worry that it wouldn't feel like you've been heard, but that's just me. Okay. So one thing that occurred to me in doing this presentation, which I learned so much. I'm so happy I did this. I really learned so much. So there's public administrative hearings by the Michigan court. They occur 4 times a year. There's one on September 25th. There's a website, and this is kind of blurry, I think. You can subscribe to all these things from the Michigan court system. You can get emails and all kinds of things. So I don't know, that seems really cool. And then there's a hearing, like I said, September 25th. And one thing on the agenda is whether to amend the code of conduct. So it's worth taking a look at. Right now, Michigan's code of conduct doesn't have the sort of, I don't want to say approved, the ABA like model code of conduct. It doesn't say, let's get all this up here. well, I'm not finding it, but it doesn't have as firm of a statement as the ABA has, and Michigan's one of only 3 states that doesn't have the judge shall recuse him or herself if they feel they may be not be able to be impartial. And Michigan's is more like the judge should consider it. So you can look and see what I didn't get it for you, I'm sorry. You could look and see what the wording is that they want to change the code to, and you can comment. And so it's a proposed amendment to the Code of Conduct to incorporate the ABA's model code. So I guess I should have been more clear on that. So it's the code about public bias, prejudice, and harassment. So when you do participate, you'll know that you did when it says that there's an order that changes something in the Michigan Supreme Court or the Michigan rules, and it says after a public hearing, they've decided this. So it happens 4 times a year. Thought it'd be interesting to see how we can all participate. So I'm allowing a lot more time for questions and answers, and I hope you have some because let's see, got to get the mic. Let's see, where's the mic?
A question from earlier when you had the whole being disqualified from being on a case. What do you do if you're like in a very long case and you've been on it for months and you realize that there's a problem and that you shouldn't be on this case? It happened to me on the jury. I was in the jury 3/4 away. I knew one of the witnesses that I didn't know I was going to know. They decided I could stay, but what does the judge do?
Wow, that's a really good question. Well, I guess one thing is the judge, he or she could ask the parties, would conference with the parties, the attorneys, and say, okay, here's this problem. Is it a problem for you? And because they could waive it. Like I said, they can say, okay, you have this problem, but it's okay. We're going to keep you on in the interest of time. I mean, time's important to them too. There probably could be, if it was a bench trial, just the judge, it probably wouldn't matter much. Because the judge could, in a jury trial, the judge could say something to the jury, I suppose. I'm not sure about jury trials because I only did one in my whole career. The other thing would be, I suppose, like if a judge dies mid-trial, they get the transcripts and give it all to another judge. So, I mean, that would be very time consuming. I guess I think the best approach would be to talk to the attorneys and see if there's a way around it, if there's some other witness they could bring for that same issue. I mean, if it was a fact witness, somebody who saw something, I don't know. But yeah, it's a hard, what happened in the jury trial? Yeah, that's what you said. They let you stay?
Both sides asked me questions and then
Yeah.
I said I could stay.
Yeah, okay. Well, that's a very reasonable approach.
I mean, I had no idea I would know
Yeah.
the witness until they brought
Yeah.
this,
Usually they tell you who
but I wouldn't have known the name anyway. It was a
okay.
waitress,
Oh.
that we see all the time, but I had no idea.
Oh, okay, yeah. Well, even if they give you a list at the beginning, things can change during the trial and they may need a rebuttal witness or a rebuttal witness who they wouldn't even know themselves until after they hear the evidence. So, question from the chat?
We do. This is from Norma. She asks, have all cases on the shadow docket been litigated at a lower court before coming to the Supreme Court?
Yes, litigated, I don't know how much litigated it means, but they've all been ruled on by a lower court judge. Otherwise, they couldn't get there. The Supreme Court can't go out and pick cases.
I have one other question too. With the shadow docket, that's considered an emergency.
Yeah.
So how is emergency defined?
Oh, wow, that's a good question. I don't know that it is defined. I've never heard it defined. I guess, what do they say? An emergency is, I don't know. I don't know. I don't think it's officially defined. I'll find out though, I'll look and put it in your list.
One of the trends that's been very concerning over the last couple of years is the increasing use of judge shopping and that. Unfortunately, the idea that you can just sort of finagle and find a judge that's going to be sympathetic to your perspective seems to increase the perception that this is a very, very political process in that. So do you think there should be any reform of that? Should there be any increase in the rules in that? Let us know what your opinion is on judge shopping.
Okay, well, thank you. So I did read something about suggested reforms. For example, I don't know if you remember the case that was brought in Texas before a particular judge that they knew would be sympathetic, just judge shopping, total judge shopping. But it's very true that cases are brought in places where they might be sympathetic. I mean, it does create that appearance of politicization, and it's not a good thing. I don't know of any specific reforms. I know at the trial level in Illinois, and I don't think it's quite the same in Michigan, you have a right to change your judge. You have a right to, for one free change of judge for no reason. And other than that, you have to show bias to change the judge. So I'll take a look and put into the source and resource page something if I find anything that you could look at. Sorry, I don't have a better answer.
You may have already answered my question because it had to do with the same topic, but how are judges chosen? Is it by lottery? Is it by rotation? Or because it sounds like if you can choose the judge, you can pretty much bias the decision.
Right, isn't that sad to have that impression? I believe it's random. I think there's like a randomization somehow. I don't know specifically. There's only so many judges and the cases come up, and you do see certain judges seem to get similar kinds of cases. I don't know. I know that I heard that when I was a judge in Cook County, that the clerks who were coming to file their cases would kind of sit real close to the desk where they're giving out the name of the judge, and they kind of listen and kind of try to figure out who would be next on the list so they could wait and get a different judge. I don't know if that's true. And anyway, they'd get one free change of judge. So I don't know if it would work. The other side would get one free change of judge anyway. So, but I can look into that.
This is at the federal level. There's a perception by some that the Department of Justice has lost some of its impartiality in terms of how it operates, whether that's true or not. But as you look at the decisions that are made by judges, if in fact there's some difficulty in enforcement, what is the backup plan? Or maybe it's not the Department of Justice that enforces decisions from the federal bench.
Oh, that's a really good question. I know that's been on people's minds. Well, it's basically my understanding is it's the contempt power. So the court itself has the power to enforce its own rulings. It's not the Justice Department. However, if you are in contempt, I mean, I suppose there's criminal contempt, and I think you can be, I know in some cases you can be jailed for criminal contempt. But it's the judges themselves, it's my understanding, that enforce their own orders. Right.
Carries it out. Sorry.
Well, like for example, for myself, when someone was disrupting the courtroom, it was direct criminal contempt of court. So I told my deputy sheriff to take him out. So it's I guess it would be the assistance to the judge in the courtroom as far as the bigger picture of an administration not complying with the court's orders. I don't know. I don't know. I can try to see if I could put some kind of answer in there. So I just don't know.
Question, Kathy. Can you talk a little bit about the role of precedent? I think that's another thing, especially from the High Court. We've watched Senate confirmation hearings. Everybody says how important it is to uphold precedent. And I certainly don't know any stats on it, but it would seem that that's maybe not so much the case anymore.
Well, I don't know. Precedent's really important. And one of the things I read said that Justice Alito said there was no overruling of Roe v. Wade. It was, so I don't know. I mean, you follow precedent. You have to follow precedent. Go ahead. What, sorry.
Then I guess my follow-up question to that is, are the rulings getting narrower? It almost seems like only a certain amount of facts are being presented, or only one line of reasoning is being followed in a very, very big picture. Does that make any sense?
Yeah, so I guess thinking about the process, so you have the facts, and the reviewing courts they can't alter the facts. The facts come to them. They're not supposed to change the facts because they're not finders of facts. They're reviewers of what the lower court did. So the lower court, takes the facts and sees the law that is relevant and then applies that law to those facts. Now, like I said about the case where I was searching for a precedent because I didn't like the result. I mean, you can't change the precedents. I mean, they are there. It's just a matter of how you distinguish them, how you say your case is different from that case. So there is a way to really narrow it down, as you said. And maybe, I don't know if it's happening more, or imagine how many precedents there are now and how available they are for you to think about. So you have to rely on the lawyers to give you their understanding of the precedent. And then you can look outside what they give you. If you go way outside, you might want to tell them, look, I found this other precedent. Tell me what you think it means. And then you can gather more information. So it's hard. And I don't know. I don't know if it's changed. It's a good question.
Just a comment in reference to a previous question and then my own question. On the issue of enforcement, my understanding is in federal courts, at least, it's the U.S. Marshal Service that is responsible for enforcing judicial opinions or things like criminal contempt. But that obviously leads to the question of, well, who controls the U.S. Marshal Service? So it's just kind of a circular thing, I think. My own question on the issue of judicial independence. Do you know of any research or barring known research on this question? I'm interested in whether or not you have your own opinions. Independence contrasted with how judges end up in their roles, whether it's appointment versus elections. Any research on whether one of those two forms is most compatible with independence?
What a great question. And I'll see what I can find on it. I'm sure I read a lot, and I think there could be something on that. I'll just have to take a look. Good question.
When you're considering a panel of judges like the Supreme Court and two different sides come up. Sorry. Shall I start all over?
Yes, please.
Okay, here we go. When you have a panel of judges like the Supreme Court, and obviously, as we well know, there are two different sides that come up, but the law is the law. So there's obviously interpretation there, correct?
Right.
That is supported by the precedents that are chosen to support that interpretation.
Right. So I think for many propositions, you can find a supporting precedent. It's possible in many cases to go either way. So I think that's probably true.
How is the, like we hear about justices that are originalists
Mhm.
in terms of Constitution. How does that, how they view the Constitution? Am I doing it again?
You're worth hearing.
Oops. Okay, let me try again. So how does a judge's view of the Constitution, if they are originalists, see how people have to take care of that? So how do they, does their perspective of the Constitution, if they're originalist or what's the other textualist, how does that influence how they look at the law?
Okay, so let's say, I'll just try if this example works. So say you have a statute and it says it has a sentence in it. And what you have to figure out what the meaning of that sentence is and apply it to the case. So there's rules of what's called statutory construction. So there are rules that you apply to how you look at the statute. So I think it would be the similar thing where if you're an originalist, there's rules that an originalist would follow because their goal is to get the original intent. And there's rules that the textualist would follow because there's goals that the textualist wants. So you have these sort of rules that affect your way of looking at the case. They're not rules that are written down. They're just sort of, well, the rules of statutory construction are written down, but they're ways of looking at it. I think I wanted to say, and I forgot to say, that to me, if you have an approach, say originalist or textualist or whatever approach, that's the way you do your analysis. I think the problem comes in if you have an agenda. It's when you have an agenda that it causes a problem. Because if you're just applying the law to the facts and you read the law a certain way because of your belief in how, or your knowledge or of how the law should be interpreted, if you're just applying your way of interpreting the law to the facts, that's fine. But if you're doing it in a way to accomplish an agenda of your own, something you think should happen, that's a whole nother thing. And I think that's the problem. There was a case, a judge in Illinois, this was quite a while ago, and she was anti-gay, and she sat in an adoption court where lesbians were adopting their partner's biological child, and it was permitted, it was legal, it was fine. And this was, like I said, quite a ways back. And she just didn't think this was right, and she had an agenda. So she would take the case, even though she knew she had an agenda, so she should have disqualified herself. She would take the case, and then she would look for people to appoint to the case who were also anti-gay adoption. And hers presiding, she was called to the presiding judge's attention. He took her off the case. She fought it. And eventually, she's gone now, but it was an agenda. So if you have an agenda that this should happen and you're using that agenda, you're working with that agenda in your rulings, it's not okay. But if you see the Constitution a certain way, and you think it should be read a certain way, and you use that reading to make your decision, I mean, that's fine. How they get the two sides to meet is the whole other question, I guess.
Do you interpret the recent presidential immunity decision as broad as Trump is interpreting it? I mean, is he never going to be liable post-presidency?
Wow, I don't know. I think there are rules that things should be interpreted as narrowly as possible, especially if they're constitutional situations. So, I mean, there are rules on how to interpret. Sometimes you don't even get to a constitutional question because you're supposed to avoid them. That's in certain situations. So, but as far as that goes, I would think it should be interpreted narrowly, but I don't know.
I'm thinking that we should be, if we're not, maybe we're not paying attention. But when we have a president who says before some judgment is coming before the Supreme Court, that he's bringing it to the Supreme Court so that he will win, should we not be skeptical about the fact that the facts that you showed on the Trump versus Biden with the Supreme Court, should we not understand that that's exactly what's going on?
Wow. I think it's the appearance. I mean, it doesn't look good. I mean, you would think someone would want to do something, because how can we have faith in the court system? And we have to. Our democracy depends on it. And if it isn't as bad as it looks, somebody should, I mean, maybe it isn't as bad as it looks, but it sure looks bad. So, and what do we do?
Okay. I just want to comment on that last statement, because while you were speaking and you had that particular slide up, I did the math, and it was on that one, 84% and 55%. But that is the median, yeah, not the mean. Okay, and the mean turns out to be like something like 62% and 51%.
Oh,
so the optics are different than what the math would suggest.
that's interesting.
Just
Yeah.
So a quick question, from if a judge on the Supreme Court, like certain judges, you don't even have to know anything. You know how they're going to rule. Like, you're going to know how Justice Thomas is going to rule and Justice Jackson is going to rule. It doesn't even matter, because it'll guaranteed before the case starts, I know how they're going to rule. Those ones that are in the middle that make the decisions, you would think history views them differently, because they make the big decisions that stick for 100 years. As a judge, you would think you would want to be in that group and not in those two extremes. Why are they, most of them, in those extremes?
Maybe because they're human. Maybe because they, well, I have to say from personal experience, there was a line of, well, how do I put this? There was a way of approaching a case that made me really angry. It just seemed wrong. And it's hard to get over those emotions of injustice or something really wrong. And if you, I mean, I noticed that Justice Jackson is 0%. I mean, I'm sure she's applying the law to the facts, or not applying the law to the facts, because they're not, well, applying the law to the facts that are already figured out by the lower courts. And it just comes out that way. Maybe I don't know. I mean, it's kind of sad, because you don't really want someone to be extreme. You'd rather have everybody you'd rather not know how everybody's going to decide before they decide. I mean, that would be more independent and less political. But I think it's your view of justice, really, I suppose. What's justice? What's the just result? What's the impartial just result? And apparently, to her, she's not going to, she sees it the way she sees it. And that's who she is. That's how she sees it.
Question on, again, the shadow docket. Is there a sense of how much more material is going through to the Supreme Court as an emergency historically? I mean, it just seems right now everything is an emergency.
Yeah.
And so then my question is, how durable are the rulings in a shadow docket case historically? If everything is an emergency, are those judgments as long lasting as those that take place through a more traditional path?
Well, my answer would be that they're temporary, so they could change by the time they brief and argue, and they are not permanent orders. So And that's why it's been so hard for the lower courts, because they're temporary orders and they don't say much about why they're the order that there's not really a precedent. I mean, that's what this article kind of, it said, they appear to set a precedent aside. They seem to be changing things, but they don't say why. And they haven't had a lot of briefing or argument on it to weigh in. And a lot of cases in the Supreme Court get a lot of amicus briefs, which are briefs by people who care about the issue, and they're allowed to bring it in even though they're not lawyers on the case. They have to ask permission. So there's none of that. None of that is in these cases. I don't think. I'm not sure, but I'll check.
We can take you out of your Solomonic role here and just ask, there's at least 3 books that have been published by Supreme Court justices in the last couple of years here. Do you recommend one? Do you recommend them all? Because I think these are the people we want to hear from in their own words, that about what their opinion is in these things. So do you recommend one or another of these books?
You know, I haven't read any of them except for Justice Breyer's. No, Justice Breyer wrote a short one, a very short one. I think it's called Politics. Wait, let me find it. Anyways, it's going to be in your resources. And it's that's the only one I've read. I think it would be interesting to read them. The most recent one is Justice Barrett's. I think that would be really interesting. Although the reviews suggested that it wasn't really as much of an insight as you wanted to be, but I don't know. I didn't read it. Justice Breyer wrote one called The Authority of the Court and the Peril of Politics. He wrote that in 2021. It's very short. It's worth reading. I think that one's worth reading. It doesn't talk a lot. It's not like gossipy or anything, but it's worth reading. Thank you very much.
Well, Kathy, thank you very much. And I just want the people in the classroom, take cake with you. We've got plates. Take cake with you. All right. Thank you.
Thanks.